And fans of Britney Spears have been glued to the story of the singer's battle over a conservatorship that her father has over her. She has lost many of her basic rights. Taylor Musgrove joins us now in the studio with more details on how this happens and how it might apply here to Iowa and conservatorships here. Good morning, Taylor.
Good morning, Andy. What shocked many about Spears' conservatorship is the allegation that the appointment is infringing on her basic rights. On June 23rd, Spears testified in court, stating that over the last 13 years, she has had no control over her $60 million estate and has to pay her conservators, including her father, wasn't allowed to get married or have more children, was required to take medications such as lithium, and was forced to work even though she expressed that she did not want to. Now, conservatorship is defined as a court case where a judge appoints a responsible person or organization to care for another adult who cannot care for themselves or their own finances. And every state has different laws surrounding conservatorships. So the question is, could a case like Britney Spears happen here in Iowa? Well, the short answer is yes. According to Frank Tenuta with Iowa Legal Aid, the state's laws were fairly loose, leaving many Iowans under conservatorships vulnerable. However, just last year, the state enacted a new law. Now, under this legislation, in order to appoint a conservatorship in Iowa, the court must perform a statewide background check on conservators. There must be a professional evaluation on who is to be the protected person, and an adult respondent is always entitled to an attorney separate of their proposed conservator. Now, Tenuta has been helping Iowans fight against conservatorships for over 35 years and says the biggest problem he sees is not the control over a person's money, but rather the control over a person's rights. The managing attorney says he hopes Iowa will start enforcing more partial conservatorships.
If there is a need for it, it should not, it doesn't have to be all or nothing. There are situations where there might be a need for something, but we don't need to control every aspect of the person's life, right? Let them make as much of their own decisions as they possibly can safely do.
Now, other rules Iowa enforced last January for administering a conservatorship include conservators being more transparent with a protected person's finances and how long they expect the conservatorship to last. And adults of all ages with an intellectual disability can be appointed a conservatorship, but it's most common among older adults, Andy.
Okay, kind of like power of attorney, but to a more extreme degree. And I think you just kind of answered my other question there. Would adults with intellectual disabilities or older adults would most likely be the ones who would have a conservator appointed in Iowa?
Correct, such as dementia.
All right. Thank you very much, Taylor.